morning. You are watching Focus on Parliament on Civic Space TV, brought to you by the Center for Constitutional Governance. I am Kwagala, your host. The Judiciary, which is the third arm of government, a creation of the Constitution, is principally charged with the mandate to administer justice in the country, thus underscoring its crucial role in the protection and the promotion of the Constitution. On today's edition of Focus on Parliament, we discuss and review the performance of the judiciary in the execution of this critical responsibility. Our esteemed viewers, you are most welcome to this program. I now have the pleasure and the honor to introduce to you my esteemed guests who are with me in studio today to help us dissect this topic. Let me start from my extreme left. Is the Honorable Lyandro Komakech.
Lyandro.
Yes.
Yes.
Honorable, it's a pleasure to have you on the program. Say hello to the viewers.
Yes, hello viewers. I'm happy to be back again here to engage with you in these issues of judiciary and the protection of the Constitution.
It's a pleasure indeed. Yeah. And joining us also today is Professor Ndebesa, who is a regular on the program. Professor is a distinguished academic and a political commentator. Prof, you're most welcome to the program. Say hello to the viewers.
Thank you, and good morning to the viewers and listeners out there. And I'm happy to be here to share with you issues of national significance, more so of nation building.
Many thanks indeed, Professor. Honorable, let me start with you. The Constitution mandates the judiciary to dispense and administer justice in the country. And it, in no uncertain terms, envisages a professional, competent, free, and independent judiciary. In your view, do you think the judiciary has lived up to this promise?
Well, we can measure their performance based on this political stability of the country. But if you look at it in terms of evaluating the performance possibly since independence, I don't know what period we are measuring their
since the promulgation of the 1995 Constitution.
Okay, I think the promulgation of the 1995 Constitution also carries with it history that Professor knows very well, that our independence Constitution had a lot of challenges that actually led into breakdown of politics in this country, even at a violent level, where we even generated rebels to fight and all this. So the 1995 Constitution, if you look at the preamble, it gives us an alert that aware of our history. Now, aware of our history is based on the legacies of violence we went through at the colonial period and then at the post-colonial period. Ugandans have never enjoyed their constitutional rights to the maximum. So the 1995 Constitution was thought to be the best answer to many challenges that we went through. And that is why they generated delegates to come from various areas of the country and agreed that let there be another constitution called the 1995 Constitution, and that was it. Now, in the provisions of the 1995 Constitution, the judiciary was given very strong independence powers, and the executives were given theirs, the legislature were given theirs, and if you look at in the Bill of Rights, Chapter 4 of the Constitution, it clearly highlights all the fundamental rights. Actually, we kind of just copied the Universal Declaration of Human Rights and put it in our Constitution, which is okay. And now when you look at from that period to date, how the judiciary has been at the core of protecting the Constitution, there's a lot of challenge. It is good and bad. For me, I give you the experience of the bad side of it, because I remember the 1995 Constitution, when it was promulgated, the president made one statement in a cocktail at Serena, then Nile Hotel, that this Constitution is good, but there is one issue of land. I'm not satisfied with the issue of land in this Constitution. And we thought, like, as very young people, why is the president complaining when this thing has been done?
What were his specific misgivings?
I think he did not want land to belong to the people. He wanted government
to own the land.
To own the land, because he said that it would create a lot of obstacles in development processes, because everybody would want you to compensate them and all these, and that's why you see corruption around all these issues of land. So for me, the first thing was I witnessed the party, the Democratic Party, going to court that NRM is not a political party. Right? That time it was called the movement system. Yeah. Zakaralum, Reina Kafire, and Semugere. So they pushed the case, which we thought would not go the way it went. But to our surprise, the Constitutional Court ruled in their favor that actually there is no movement called NRM. It is a party. It's a one-party rule. And that is what now generated the beginning of a push towards a referendum and the president justifying itself. So to that extent, you could see that the judiciary was demonstrating capacity of delivering and justice and protecting the citizens and in their interest, enforcing rights, you know. So for me, in terms of enforcement of rights, I saw that one. And of course, that many other judgments were passed. If you look at the 2018 on the presidential age limit, is it age limit? Yes. Where of course, they said it was okay, but then they said the procedures were not followed. That was the ruling on the constitutional, on the issue of
that was the ruling. Yes. On term limits.
On term limits.
Not age limits.
Yeah, on term limits. So you could see they were trying their best, but also trying to balance the executive. Now, the worst came, if I look at in terms of protection of this constitution, you see, when the issue of age limits and term limits were enacted and other things, there were supposed to be locks on them, you know? And these locks, the safety locks were not there. So I remember when we were in Parliament, we had to go for violence, because the state could see that the challenge was they could be overpowered. The Toji Kwatako, if you remember those issues. Now, that demonstrated that actually the only safeguard we were left with was the court. But you could see that all these things were left loose the way they were for certain strategic purposes. Now, instead of the court saying, well, you need to protect these pillars, these key pillars, for good governance, but nothing was done. And the constitution was left open. The judiciary, even when they knew these were there, you know, it became a very big gap. So at the end of the day, on issues which are simple and small, the judiciary is very strong and effective. When it comes to political decisions that have political implication, the judiciary is very weak. They do not stand to defend the interests of the constitution. I think Kenya has demonstrated a better position than us in terms of protecting the constitution, because this constitution is protected for the interests of the citizens. So if you look at to date, I think our constitution has been so riddled that you hardly can see that it is something which was promulgated in 1995. It is full of patches in what the Baganda called Chiraka. Everything has been amended to the extent that many say, why don't we again go back and get another process to do this thing? So as far as we are concerned, I think at 80%, the judiciary's independence is eroded. They do not have the capacity. I think even the Minister of Justice of recent made a statement, which was very, very funny, that there's a lot of political interference with the judiciary. to the extent that certain decisions are now being interfered with from the executive. Now that is a statement from the Minister of Justice. So it demonstrates that as far as we are concerned, I think we are not being very effective in matters of steering the protections of the rights of the citizens of Uganda. Yeah.
Prof, considering the turbulent political and constitutional history of our country, if you were to give us a comparative analysis of the previous governments in terms of their performance, the performance of the judicial in the protection of the constitution, vis-a-vis the NRM's performance in the protection of the dictates of the 1995 constitution, what would be your assessment?
Before that, let me compliment even my colleague over the question you had asked him about the role of the judiciary in protecting the constitution. I would want to begin by saying that, using some metaphors, that the judiciary is supposed to be the watchdog or the guardian or the watchdog or the guardian or the custodian of the constitution. And again, I want to state from here, from where you began, you are a lawyer, but I want to be educated together with the viewers out there, is that there has been a general perception that the judiciary exists with the mandate to administer justice only. I think that may somehow mislead when we put it that way. The judiciary has many roles beyond administering justice in respect of making rulings civil, like when there is a conflict between an individual or individuals, the civilians. When there is a conflict there and the society needs to be regulated, that the judiciary plays the role of mediating or regulating. And then when there is a conflict between the executive and maybe and some individuals in terms of criminal law, then the judiciary comes in. That is a traditional role or the perceived role. But there is a wider role of the judiciary besides those two. Is that the judiciary is supposed to review the constitution. Reviewing is seeing again, giving a more critical view of the laws. The judiciary is also supposed to uphold the rule of law. The judiciary is supposed to review the decisions and actions of the executive, of government people, whether you are RDC, whether you are a minister, whether you are a public servant. When you make decisions or you take actions that are contrary to the constitution, those decisions are supposed to be reviewed by the judiciary, by the courts. And I think even beyond the constitutional court, which is supposed to be reviewing the constitutional issues, all courts are supposed to review the decisions that are made by government officials, administratively that is. Even you, in your law studies, you have got administrative law. You do have constitutional law. And these ones are not about the administration of justice in a traditional way. So, in other words, the judiciary exists to review the actions of government also, besides judgment of the cases. And in some jurisdiction, like India, I am told they have gone far and have got what they call judicial activism. Where if, for example, there is a lacuna, there is a weakness within the law to address certain challenges in society, like now we would talk about, like say, artificial intelligence. In case artificial intelligence, we don't have a law on artificial intelligence, but it causes some commotion within society. The judiciary can come in and make a ruling. That's why you lawyers tell us that actually there is a sense in which the judiciary also makes laws. There is judicial legislation. So you can see that the role of the judiciary is beyond the traditional perception that it is judging cases and giving these rulings about a conflict between individuals or between the state and an individual. So, has the judiciary done that role, performed those roles? There are more than one, as I have shown you. There are 4 or 5 even. Has it done them? Yes and no. To a certain little extent, for me, I think they have done very little. Because there is this myth that actually our judiciary is independent. Our judiciary is not so independent in Uganda. And that's why I can give you the most recent case of this trial of civilians in the military courts, where the Constitutional Court reviewed that case, that issue, and made, is it a ruling or a declaration? I don't know the legal language you use. There is when the court gives orders, there is when it gives declarations, there is when it gives rulings. So whatever it made, whether it was a declaration or whatever, that civilians should not be tried in the constitutional, in the court martial. And thereafter, I think the Attorney General appealed to the Supreme Court. It is now 3 years. It is now 3 years. The Supreme Court has deliberately ignored handling that case. That shows you that the judiciary is not independent. The independence of the judiciary is a myth. And I will not hesitate to mention my friend. He's actually my friend, by the way, we know each other. When Kavuma, Justice Kavuma was the chairman or the president of the Constitutional Court. You remember how he would stand alone, because the Constitutional Court should have a quorum of 5 people. But he would go alone and give a declaration or a ruling alone and ignore the others. And the things would remain business as usual. That is the non-independence of the judiciary in its function of judicial review. You see, in our liberal democracies or in the constitutional democracies, it was envisaged that the law which is hastily made by parliament is supposed to be interpreted. So the judiciary exists, or the courts exist also to interpret the law and make sure that that law is not flouted or abused, or the powers that are given to the executive or even the legislature. The constitution, the judiciary is supposed even to review the constitution itself. That's why there is always a constitutional review. And actually, after the constitution has been passed, before it is promulgated, it is supposed to have a constitutional review, because there might be some technical issues there that need to be reviewed so that they are in line with the letter and the spirit of the constitution. Because when they are making judgments or declarations or orders, the lawyers, you are a lawyer, you know better, they don't only look at the letter of the law, you have to look at the spirit of the law. What did the makers of the law intend to cure? If they intended to cure, for example, the overbearing powers of the president, is the constitution as it is standing curing that, or it is not? Or when they are making rulings, I think, you are a lawyer, you can correct me, I'm told when the judges are making rulings or declarations on constitutional matters, they also refer to the objective principles of the Constitution.
Correct.
Because those are principles that are guiding the ruling. They don't look only at the articles and what articles say, they also refer to the objectives of the Constitution that contain principles, values, norms, and sometimes the doctrines of the law, so that they have got a bigger picture to review the decisions of government, to review the actions of government, to review the constitutional provisions. And so we need to get this bigger picture. So let me go to your question as to whether the other constitutions, the other regimes have done any better. First of all, I want to mention this one, that between 1971 and 79, there was no pretense by Idi Amin that there was a constitution. So there cannot be constitutional order when there is no constitution. And the judiciary could not have a constitutional review or judicial review of a non-existing document. So there was no constitution. There we cannot debate much. Now, between 1962 and 67, we had challenges. We were still new, and things were still being practiced. So we didn't have much time on ourselves to review some of these unconstitutionality, but even if they are not unconstitutional as such, but there could be lacunas, there could be weaknesses in the constitution. But although I think the judiciary made its pronouncements. But I want to say that I'm not a lawyer and I may not have followed constitutional history, many events, but I think somewhere like in 1964 or thereabout, the government of Uganda, under the executive leadership of Milton Obote, people normally talk about Kabaka as president of Uganda, he was just a nominal head. The executive powers were with the prime minister. They abolished denominational schools. You know, before 1964, you studied in a Catholic school if you were a Catholic, and Anglican school if you were an Anglican. There was no way you would study in the other school. Anglicans were somehow liberal and would admit Muslims, but the Catholics were rigid. They would not allow anybody who was not a Catholic to study in their school. So the government of Milton Obote abolished that arrangement. And the Catholic Church, I think, took the case to the courts, and the courts ruled that the government was unconstitutional. And Milton Obote said, you can make your rulings, me, I'm continuing ahead. The denominational schools are hereby abolished, and they were there abolished, even against the ruling of the courts. So that is one example to show that there has not been independence. But even in the recent past, even if we don't have to point out the rulings, the atmosphere, the political atmosphere and the landscape, we can give some statements that have been given by President Museveni. At one time he said, you courts should not interfere in political matters and these illegal matters as such. Yours should be actually to judge cases of chicken thieves and other robbers, but not to deal with issues of public importance like political issues. And he has always said that, he told the courts that, please don't give people bail. The most recent was about 2 weeks ago, or less than 2 weeks ago, when he said, don't give these thieves of PDM money bail. I have directed that, he directed the police not to give bond. But even he said, I'm going to see the Chief Justice so that they don't also give bail. And he has time and again said, don't give bail to certain categories of people. So the whole notion of judicial independence, the independence of the judiciary, is questionable. But I want to repeat myself by way of summary to say that the judiciary is the custodian, is the guardian, is the protector of the Constitution, and it is supposed to make itself, pronounce itself, make orders and declarations when they discover, that is the judiciary, that the government or the executive members of whatever category have made decisions or have acted contrary to the Constitution. They are supposed to be brought order by the judiciary. And in this case, it does not have to be the Constitutional Court which reviews the constitutional provisions as such. But if there is no rule of law, if there is no observance of human rights, the judiciary is supposed to intervene, to come in and make its ruling or declaration or order so that we have got smooth running of the state. What do I mean here? As my colleague has pointed out, the judiciary also exists to promote good governance. And here good governance is big. It also exists to promote democracy. So when you talk about good governance and its elements like transparency, accountability, responsibility, and things like that, the judiciary is supposed to be guided by those principles of good governance, because its role is to promote good governance, to promote democracy, to defend democracy, to defend human rights, to defend the rule of law beyond the traditional, conventional, popularly known role and function of administration of justice. So I want the viewer there to agree with me, but if you don't agree, you can always also intervene, that the role of the judiciary is not merely to administer justice in the sense of making rulings concerning conflicts between the individual and individual, groups of individuals and individuals, and between the so-called criminal law. No, it is beyond that. It is big. And actually, when you read most literature about the judiciary and its role, the first definition you get is that the judiciary is supposed to interpret the law. Interpreting the law, not necessarily in respect of judging cases when it's administering justice, but it's interpreting the law in relation to good governance, promotion of democracy, and the larger picture of conflict of interests.
Honorable,
yes.
Reflecting on Professor's submission, there is a growing sense of frustration among the citizenry that the judiciary has increasingly become compliant. It is
compliant or complacent?
Compliant.
Compliant.
Compliant, not complacent. Compliant. Compliant to the whims of the executive branch of the government. In a sense, it is beholden to the wishes of the executive. If you were to contrast, for example, the decision of Charles Onyango and Andrew Mwenda, that landmark decision against the Attorney General, which guaranteed the freedom of expression and association, and then you contrast it with the current times, whereby the Supreme Court is shy on considering and determining an appeal which touches the very basic of rights. The right to a fair hearing, for example, the right to freedom, the right to liberty, coming strongly on the heels of the trial of civilians in the General Court Martial for political charges. A case in point is, of course, now the ongoing trial of Dr. Besigye alongside his colleague Haj Obedi Kamlegeya, again raising key constitutional and political issues. So the question I want to put to you is that should we still have faith in the capacity of the judiciary as currently constituted, especially the leadership, that it can guarantee the fundamental human rights of the Ugandan citizen?
Yeah, I think it's twofold. First, I appreciate Professor's intervention on the issues concerning the judiciary. Now, when you look at situations where the judiciary is no longer on the rail they were supposed to be on, they are now moving alongside the executive. And this is very dangerous. When we were in Parliament, I remember when we were doing the amendment on the Judicial Act, it was supposed to, the whole objective was facilitate the judiciary so well and let them have a tenure of office that guarantees them with total independence. They have good money. They will not rely on anybody else, not executive. Even in that retirement, they retire so well. Possibly, this could be a cure towards pushing the judiciary to have political inclination. But as you look now, it looks like the whole thing is forgotten, because I've seen the Chief Justice even debating with the President on events. I remember on the, was it 2 years ago when they were,
The bail question?
yeah, the bail question. The President went, as of course, as the leader of the executive. The leader of the legislature was there, and then the leader of the judiciary was there. So it became a debate in front of the media. The President is directing the Chief Justice that I do not deal with issues of bail and stop it. You know, the Chief Justice fires back. We shall not do it. It is not possible, Mr. President. We have to follow what the Constitution guides us. But the President has insisted. If you look at the trend of the President's speeches on the issues of you are innocent until you are proved what? Guilty. It remains. The President does not believe in that. The President actually believes that you are guilty until you are proved.
You prove your innocence.
Yeah, because that is the French system.
No, at some point, if I can come chip
Yes,
in,
yes.
I think the Chief Justice somehow yielded to say, I will give regulations.
Yes.
I will give guidance.
Yes.
Which he did.
Which he did.
But already, so you can already see that the independence,
The attitude.
yeah,
Differential.
yeah, the independence is already being eroded there, and the Chief Justice is kind of giving in without telling everybody point blank that I've given in, but say I will give regulation. Regulation means you have given in. So I think the interference of the executive is too heavy on the judiciary. It's too heavy. Because I've seen in situations like the issue of Besige now, it is a very heavy issue now from the executive.
But we can add on the other
Yes,
day
yeah.
when the military
Yes.
occupied the court premises to
Yes.
rearrest.
Yes.
And they have since
Actually,
been rearrested.
yes, and now actually that is a precedent that is becoming very dangerous. That on matters where the judiciary feels that some of these people should be given their bails, their what, and even actually judgment, they cannot leave the court premises because they are being waited at the gate. So you can see the level of disrespect of judicial decisions and the level of interference by the executive in the judiciary. So I see like, I think there's a perception that, well, I remember what Jim Moses said sometimes about, but where were you when we were in the bush? You were eating sausages, you know, somewhere. Eh? So
No,
there's that.
it was in the case of Ogora.
Yes.
Ogora.
Oh yes, Ogola.
He was.
Gavi Fund
Yes.
case.
So
Where
he-
were you?
He was asking the
Yeah.
Ogora,
Yeah.
Justice Ogora, where were you?
Yes.
Yes.
So you can see the perception undermines what we would think it is good. So at the end of the day, I think the president says he has been in a revolutionary government. He runs the government through a revolutionary ideology. So notwithstanding all these normatives of independence of judiciary, the executive, the parliament, I think the reality on the ground, we may have that there's actually nothing like independence of the judiciary. You know, because you have seen how the other day when we were in parliament, we were attacked. Now this time again, I saw the other day, members of parliament found themselves into total confusion when people who are dressed very nicely in suits are boxing and kicking people. You know, those are cases, the one who Enacol generated that situation. But then they saw people who are not members of parliament in the house and busy kicking. So I think we need to be very careful, and when you do this analysis, that there's a very fine, thin line now, as far as I see. There's very heavy hand of the executive on the judiciary. Much as the judiciary is trying its best, the Judicial Commission, I think, with the new amendment of the law, I think we are pushing towards increasing very many magistrates, judges, and everything. I think we are moving towards their backlogs are beginning to go and everything else. But political decisions has a very strong hand on matters of the judiciary. Very, very strong. How it should be removed, I don't know. But I think Ugandans, in the United States, actually, where people go most is not hospital. People go most in courts. If you see the courts in the United States, from the lower level to the highest level, this is full every day. You know, people are moving in with cases, petitions, and everything. But Ugandans would want to only hear statements from political leaders. Now, if we do not build into that capacity of our civil rights, our citizens' rights, to push for things that belong to us, because these are our powers, but we have surrendered it to the political leaders. At the end of the day, their decisions matter most, you know, at the expense of the citizens who are supposed to be the key determinants of how they are governed. Because the Constitution says very well how it should be governed through elections, free and fair and regular. You have seen even in the Besigye case, I think, where the Constitutional Court, the Supreme Court made the issue of electoral reform. Electoral reform was actually a decision made that this must be done.
Within 2 years.
Within 2 years.
And it was not done.
It was not done. Now, who do you respect? Where is the independence? Because this judgment is coming in to ensure that there's stability in the country. There's political stability in the country. You know, at the end of the day, this has been ignored with impunity. I think the only thing Parliament did was to say, to rename the title of the electoral body, that Independent Electoral Commission. Now, it's quite abusive. You know, we live in this country which is so rich. What we need are good laws. And good laws that come through elected leaders that do not interfere with any processes. You know, if you look at some of our cases in the north, you cannot now determine vote through the popular vote. It must be balanced through certain other processes. So you cannot come and say, I'm going for election and I'm coming and I'm going to win. You win in the evening. In the morning you lose. That's what I did in my election. I won. By 11 p.m., I was winning very well. And I was waiting to get my declaration in the morning. I woke up in the morning at 8:30. I'm number 2. You know? So you go to court, it is also difficult there because there's a lot of interference on all matters that concern the election. So you cannot get any win. So the only thing you need to do is fall back and say, how do we generate? Because here, I've not seen in Uganda ever since these things of civic education working. Or what is it called? Electoral
voter
education, which is supposed to be the mandate by the Constitution of Electoral Commission. They don't do it. They only run a few announcements, 2 weeks to voting, and that is it. So Ugandans as potentially remains not in charge of what they are supposed to be doing. And politicians are taking advantage of that. And therefore they will maintain that advantage of maintaining ignorance of the civil rights so that they do what they want to do. And that's the greatest challenge we have. I don't know which formula we can use. Whether we send so many to do law, I don't know. Whether we do what, it is very difficult. Do you enter churches so that the church leaders begin to preach? Does it work? Because all church leaders are also now under compromise. You know, you want to become a bishop, there is a Pajero waiting for you. This Land Cruiser, the new model, 2024. Now, how do you start talking against anything? You know? So, corruption is now at the core of some of these issues. The challenges that is eroding the judiciary is now corruption. And corruption is about influencing decisions, not even sometimes money. You know? So we are in a catch-22. We thought Uganda by now, since independence, would be moving so far. Compare Singapore. Professor will tell you, all those tiger countries were nothing to Uganda, even Dubai. Amin was even taking food aid, is it to Dubai in those days? In the 70s. But look, I read today what Putin said, and I don't know whether it is true. Putin said Africa can be the food basket of the whole world. Africa can feed the entire America, North and South. It can feed Europe. It can feed Asia and Africa itself. But there is only one problem. Leaders. He said political leaders. it was amazing to see Putin quote such kind of statement. But he quoted it, you know. So we need to review. And for me, I find it is now so difficult.
To review the judicial review.
Yes. You know? What should we do?
We are laughing at it, but it is a serious
It is very
statement.
serious, yes.
Yes.
Because
Well, maybe we may need a judicial review act,
I think so.
which would guide
How
how
it should be
judicial review
implemented.
should be done
Yes.
in actual life,
Yes.
in actual practice. Sorry.
You know? You have seen judges, like there's a lady who is not even allowed to be, when she was acting judge, what is that lady?
Bukirwa.
Yes.
Honorable
It is now a big
Justice
issue
Bukirwa.
because she's very tough. And she has stepped on so many toes. Now those...
Political toes.
Oh, political toes. Now they said, no, don't give her anything. And yet, in terms of quality, is top number one. You know?
So that's a contradiction.
Yeah, it's a contradiction. If you are very good, you are a problem. If you are not good, you are very good. Huh?
So
I
who defines who is good?
I don't.
You know, Professor Mamdan wrote a book, I think, and he gave it the title, Good Muslim, Bad Muslim.
Bad Muslim, yeah.
People who have not read it don't know what he meant, but what he meant is that a good Muslim is defined by USA. And a good Muslim is also defined by the USA.
Okay.
Not by the Muslims
But
themselves, but by USA. So, and President Museveni has been making a political fun in the news, in the media, in his statements, and he would say, that one is a good DP.
Yeah.
That one, he has been referring to the good DPs.
Yeah, I remember,
think, one time it was Chitariko, another time I think it was Mbide.
Yes.
By good DP, he meant those ones who were leaning to NRM. So, who has the monopoly to define judicial review? That is the question.
Yes.
So I think we need to review the judicial review. Maybe part of what we are doing here by CCG is that one. And I want to submit once again that even the law schools in their, jurisprudence classes, they have to review how they teach the law and whether they emphasize these other roles of judges, of lawyers, of the judiciary. Because I think there has been over prioritization of administration of justice as judging cases between two conflicting parties, not looking at the role of the judiciary in a bigger perspective of interpretation of the law and interpretation of the Constitution and protection of human rights and protection and promotion of democracy, like he has been pointing out, how the judiciary should come in to protect the elections, for example. Yeah. And even if moderator, you are a moderator here, but you are a lawyer, you may have to guide us here whether also the judiciary should always wait until a case is taken to them in order to make declarations. I thought at some point a revolutionary judiciary, a progressive judiciary, should at times also see what is going on in the political landscape, in the public landscape, where something is going wrong. And they pronounce themselves on something that is going wrong, even when they have not been prompted by anybody coming to complain to them. Because sometimes you can see that there is something going wrong in terms of, for example, the executive interfering with the judiciary. And you come up and make your pronouncement or declaration. You can see how, for example, Parliament is making laws that may be overbearing, that may be, let me use this English, high-handedness. You can have you can, I don't know whether the judiciary can pronounce itself, even without being prompted, by looking at the military court-martial passing out high-handedness laws. And the judiciary now gives even-handedness I think that is English, even-handedness laws. And our current regime, government, praises itself as being revolutionary and progressive. And I thought progressive laws, progressive judiciary, can also have elements, although it has disadvantages, of judicial activism, whereby you can make declarations or judgments or orders in favor of social justice, in favor of the underclass, in favor of the dominated, in the favor of the discriminated, rather than high-handedness and judicial activism of which is reactionary, which in this case would make orders and judgments and declarations in favor of those privileged. So when the judiciary sees some privileged judgments or privileged laws, privileged decisions by the executive, can't there be some judicial activism and you intervene in order to pass declarations in favor of the underclass? I don't know whether that is allowed.
Speaking of the interventionist attitude of the judiciary, I want to ask Prof if the judiciary, today's judiciary as currently constituted, can fairly intervene in a very serious political dispute, like the one that Honorable highlighted, where the Honorable Semogerere and a number of his political associates challenged the so-called movement system. A case in point, and you have both highlighted it also on the program, you've pointed it out, where the Supreme Court, in I think 2 specific presidential election petitions, has gone ahead and issued directives for implementation by the regime, but they have been ignored. In the last election, the first runner-up, the Honorable Kyagulanyi, challenged the outcome of the election in the Supreme Court. And he was compelled to withdraw the case on account of not being confident in the capacity of the judiciary to deliver an impartial and independent ruling respecting the disputed election. So, should we trust the judiciary to continue making these interventions? Because you seem to argue that we should not only focus on the limited mandate that is spelled out
as a demonstration
in the
of justice.
Constitution,
There
as
are
simply
others.
administering the justice.
There are other functions of the judiciary.
Those function now, that is a core function, because the judiciary has got to intervene in those disputes to ensure that we have political stability in the country.
Thank you. Let me first, as a teacher now, clarify something which I know is wrongly perceived in society, or this English we learned when some of us had slept in houses without ventilators. The word capacity, people normally technically define it to mean professional technical capacity, which it is, but there is much more than that. Capacity also means the values. Do they have the values? And courage. Courage itself is a competence, is a value, is a capacity. Does our judiciary have the courage and the normative framework to stand its ground and make declarations and orders and follow them up? Now, you are giving out cases where the judiciary has made orders, like in the case of those post-election judgments, and the executive has not implemented. Can't the judiciary come up and say, now you have failed to implement in practice what we ordered, and therefore you are out of order? Can't the judiciary now intervene at that? Do they have the courage to do that? Or they are timid? So anyway, the performance of Parliament as well as the judiciary also depends on its history. The history in whose footsteps we are moving, the history of Britain, is that they had struggles to liberate themselves, they must defend themselves and create this independence of the arms of government. For example, the Magna Carta, that's 1,000 years ago, clearly spelled out the role of the judiciary and parliament and prevailed upon the king. Then I don't know, he was Henry the First or whatever. And later on, there was a glorious revolution. And at one point, actually, the King of England was beheaded by the parliament because he was interfering in the parliament and judicial powers. And the UK was, for more than 5 years, a republic. And later on, they said, okay, the kings can be restored, but on our own terms. But from that time, parliament became independent, and the judiciary also got its independence. So some of these things are through the struggle. So we have got very many references we can make and document where parliament and the judiciary, actually, the judiciary has made declarations and orders and pronouncements for the executive to implement, and the executive has ignored them. Either has ignored them or quickly, hurriedly gone to parliament to pass new laws to sidestep the ruling of the judiciary. That means that that action of the executive is done in bad faith. Are we together? Because that is done in bad faith, if I can use the political language, to subvert the ruling of the judiciary. And by extension, to subvert the law and justice. And that has been done many, many times. Now, so the judiciary rulings and functioning and outcomes also depends on the political landscape pertaining in a country. So if the political landscape is still controlist, is still authoritarian, it is very hard for having the smooth functioning of the judiciary to regulate society and to regulate the different arms of government, because the role of the judiciary is to regulate the actions of the parliament, of the legislature, and that of the executive. But we have had an overbearing executive here because of our history. First of all, we didn't have even our own constitution during the colonial period. The executive, which was headed by the governor, had its way. And we still have those legacies, the legacy of colonialism. Colonialism by itself is dictatorship, is authoritarian, is not democratic. So we still have that legacy. And then we have the legacy of the independence regimes, starting with Obote I, who could ignore the judiciary or tilt the judiciary in favor of the actions of the executive. We have Idi Amin now, who dealt away with the constitution. The question of constitutional review, constitutional debates, constitutional provisions and declarations was not there because he had dealt away with the constitution. We have UNLF period where Muwanga had become a law into himself as chairman of the military commission. You know, at one time when we were in the midst of elections, the late Muwanga made a statement to the effect that the electoral commission was not allowed to declare results. It will be me, the chairman of the military commission, who will declare results. Now, what?
In the middle of an election.
In the middle of an election. Now, what kind of... and then the judiciary then maybe was timid. I thought that is when judicial activism can come in.
Was there a challenge to that election? Was it disputed legally, let alone, of course, what for subsequently?
I don't remember quite well, but I think bits of it were challenged here and there, but the bigger picture was not challenged. But I should be guided.
It was militarily challenged.
But I can be guided. Can the judiciary make its pronouncements Or when they take advantage and there is a constitutional court, can't they go around that court and sometimes make declarations, even if they are not rulings, make declarations or orders correcting something that is wrong in the process of executive actions and the executive decisions. I think in some jurisdictions we have had progressive judiciary that stands by itself and makes a declaration and follow them up, that if you don't follow them up, we shall make another declaration. For example, asking the parliament not to give you monies because of that. But I know it will be interpreted as judicial activism, but there is nothing wrong with judicial activism. Yes, it can be negative, especially when the judiciary is autocratic, but I think there is a challenge there. So the judiciary needs courage. The judiciary needs capacity. You talked about capacity. Professional capacity could mean just technical know-how, technocracy, technical mind of the law. But for the judiciary to function properly, they need both technical capacity as knowledge of the law, but also capacity as values of democracy, because they are promoting democracy, as values of human rights defense, because they are protecting human rights and they're promoting human rights. So, audience there, when we talk about capacity, take it from me that capacity we don't always mean technical knowledge. Just like people have been talking about professionalization. There was, not long ago, there is talk of professionalizing the army to mean training them in skills of fighting. That is one of them. The other one of professionalism is imbuing the values of, for example, the role of the military in not interfering in the political disputes. Or following the constitution. For example, the constitution of Uganda says that the military is under the control of the civilians. Is subordinate to civilian authority. But you find the military not listening to civilian authority. Even the military, during even elections, especially at that time, you find some military officer making a statement to the effect that, for me, I will not be under this new person, even if you elect the person. And then there is nothing that is done. I want to be guided whether the judiciary can't make a pronouncement there and say, oh, I think you are not supposed to make that statement. You see, there is administrative law beyond the other forms of law. There is administrative law, there is constitutional law, there is judicial review. To review is to see again, to see critically. So I don't know whether the courts have the mandate to take initiative, to be active. Because if they are mandated to promote democracy, to promote the rule of law, to protect human rights. How are you going to protect human rights? By just keeping quiet until somebody comes to complain to you. By just keeping quiet, even when you have made declarations and orders and they were not followed by the executive, and then you keep quiet and you say, for us we made the order. To me, that is technocratizing, if I can use that word. That is technicizing, I think that's the right word. That is technicizing the law. And technicizing the law is missing the point. I think the judiciary, as the arm of government, and the judiciary generally, because the judiciary is not even limited to judicial officers only. We are talking, they are judicial officers, but not necessarily to the magistrates and judges. We have got other participants in the judicial process. We have got the DPP's office. We have got the registrar, the registrars. We have got the solicitors. We have got the attorneys. These are part of the judiciary. And I think that whole group needs capacity in respect of values. That is why the Ministry of Education has now gone to the competence-based curriculum. The competence-based curriculum is trying to cure the mischief of thinking that education is only giving out knowledge. And it's we have very many educated Ugandans who have got the capacity, meaning knowledge. No, we have also to go beyond capacity as knowledge, to go to capacity as values, as norms, as skills, as empathy, as sympathy. Because do we have judges who have got empathy towards, for example, the underclass people, such as the women, in terms of gender law? Do we have lawyers who are progressive enough to say we have empathy for social justice? And therefore we can exercise judicial activism and make rulings and orders in favor of the underclass, the underprivileged, the downtrodden, the oppressed, the unemancipated. Because that is where I think judicial activism comes in, and we can have judicial legislation deliberately done by the judges who have got a progressive value system, and they want to emancipate society and put it on a footing that is commensurate with a good society. Because unless we do that, we shall continue having conflicts and violence. Unless we regulate society in a free, fair manner, promoting social justice, and I would enjoin, I think that is the language you people use, the judiciary, when they are passing laws, and not passing laws, they are judging and making orders, to listen to their law school studies of jurisprudence, that's the knowledge of law, and locate it, immerse it, put it into the values behind the making of laws. But you find a judge going so technical, as if he didn't do jurisprudence on our side in humanities, we call it epistemology. And so you don't simply judge because you have been given laws and you technically interpret them. When you are interpreting laws, you will correct me if I'm wrong. I thought when you are interpreting laws, you are not only informed even only by facts, you are also informed by doctrines.
And the context.
And the context. And doctrines of law. Because where did the law come from? What is the history of law? What is the history of the judiciary? To regulate society for the good of society. But you don't just make a ruling just because that is what the law says, and you make society fight and you make society clash. Because the purpose of the law is to regulate society for the good of society. So how do you just make laws technically as if you don't have, incidentally, I think also in law, judicial officers have got what they call, I've failed to get the correct word, but they can rule in their own perception.
Discretion.
Discretion. They are discretion, but that discretion must be informed by the values of law. So
judiciously. Supposed to be exercised judiciously.
Judiciously. Can't they exercise their judicious mind and say, even if the law, which was made by a parliament which may have been biased, which is middle class, bourgeois, you know, they support the dominating classes. Can't I say, oh no, to me I have to make a judgment based on my values for social justice, for gender justice, for environmental justice, and use my discretion. Judges, can't you use your discretion based on your judicial norms, not necessarily on the technical laws made by these high class, high-handed, this corrupt, sometimes the corrupt parliament. Finally, he talks about corruption. I want also to, I'm a teacher, let me give this exposition also.
In a minute, Prof.
In a minute. When we talk about corruption, people immediately jump on financial corruption. No. Conflict of interest is corruption. High-handedness is corruption. Supporting the dominators to dominate the dominated is corruption. Corruption can come in, and being biased is corruption. Being corrupt because the appointing authority did this or that. You know, we have got a strange situation in Uganda under Museveni. This is not to criticize Museveni or government as such. You know, in USA, allow me just a minute to explain this one. In USA, judges actually are appointed subjectively. They are appointed according to
the parties.
to the party. But they have a choice within their judicial system, within their political system. They know that the president who appoints will only be there for 8 years, not even 10. And therefore, and yet the judge is supposed to be there for life. Therefore, the judge will go beyond the lifespan of this president and this party. And therefore, he will not be biased. Now, we have a situation in Uganda where we have somebody who has been there for 40 years. So, the judges he has appointed, if they were his cadres, now they continue. We have a unique situation. Recently, I was at the, I will illustrate this one. Recently, I was at the Uganda archives. The archives is where they keep those old documents.
Yeah.
So the law, which was left by the British, we still have, is that you are not supposed to expose documents of government in less than 30 years. They are supposed to be put to the public in 30 years. After 30 years, sorry. Now, the logic was that after 30 years, there will not be conflict of interest because you don't expect the officers who were leading government today to be there 30 years. Now today, the National Archives cannot allow you to look at those documents even after 30 years because the sitting government is still there and therefore you will create crisis if you expose those documents that are touching the current regime. So that is the challenge we have. I think people can discuss it.
Thanks, Prof, for your perspective. Focus on Parliament now takes a short break. Do stay with us. See you back shortly.
Digital rights are those human rights and legal rights that allow individuals to access, use, create and publish digital media or to access and use computers, other electronic devices and telecommunication networks. Digital rights include a right to freedom of expression, information and communication through technology, a right to privacy and data protection, a right to credit for personal works, a right to universal and equal digital access, a right to identity, a right to anonymity, a right to be forgotten, and a right for protection of minors, among others. The state's digital rights are frequently violated through various unfair actions, for example, blockage of websites and social networks, theft of credentials, unauthorized use of people's data for personal gain, privacy intrusion, online censorship, arrests and intimidation of online users, internet blockages, and the proliferation of laws and regulations that undermine the potential of technology to drive social, economic, and political development worldwide. It is hence every citizen's responsibility to respect rights of other digital users and to speak out or report to the responsible parties when one's rights are violated.
Welcome back. You are still watching Focus on Parliament on Civic Space TV. In this segment, we continue the discussion by assessing the critical role of the judiciary in the protection and the promotion of the Constitution. Honorable, let us now spotlight the critical role of the other stakeholders who, in partnership with the judiciary, are meant to uphold and protect and promote the Constitution. I want to cite the critical function of the Uganda Law Society, which is the professional body for the practicing lawyers in the country. Lately,
but established by law.
Established by law, yes. It is a creature of a statute.
A statute.
A statute of Parliament. So since the election of the new Uganda Law Society, Mr. Isaac Semakade, he has made a strong case for the advocacy and the proposed implementation of reforms to try and cure certain wrongs and mischiefs in the judiciary. The other week, he released a strong missive directed at the Chief Justice to address certain urgent issues in the administration of justice in the country. A case in point is the viewpoint that the executive has a very strong hand in the appointment of the judges in the country. His view is that this process should be transparent and there should be broad public participation. Even the process of interviewing the judges should be before the media, so that the public then gets to also conduct some sort of vetting and there should be a convergence. So the question I want to ask is that how would this fit into the agenda of the judiciary protecting and promoting the constitution, in your view?
I think Semakade's views are good views. Only that the approaches that Semakade uses sometimes is what scares many. Semakade, when he was campaigning to become the president of Law Society, he said for him it is going to be a radical bar.
Banging the table.
Yes, he will bang the table. So banging the table means we are going to approach everything from a very radical point. And you have seen of recent how he has been pursuing, being thrown out and then throw the others. They have been playing with powers in the leadership of ULS. And for me, I agree that the manner or the way in which we elect judges or we appoint judges needs to be reviewed. You see, the judiciary in Kenya is a little bit stronger because of how they go to office. It is a very rigorous process. Once you are there, you will not fear anybody. You will engage properly. But for here, I think there's a lot of other political decisions that are taken for many of some of these judges to be appointed. Because there's scrutiny about where is your inclination. They even go to the extent of following up all your, from childhood, how have you been? Where have you been? Which side of the world are you? Are you pro us or pro them or where? So at the end of the day, it affects those who could have been very good judges from being appointed. You have seen even the way the Judicial Commission is constituted also needs to be reviewed. I feel it should be an open process that allows those who become members of the Judicial Commission to have a credibility of the public. But as of now, I think it depends on a few who make these decisions that take those people into those offices. So their performance, therefore, becomes a patronage performance because there's fear. If we don't do like this, we shall be seen to be doing wrong things. And so for me, it goes even to the extent of reviewing the law on appointment of judges. In Kenya, it is now democratic. Now, the whole public can now talk about you for a whole day. On TV. On TV, it is live. But for here, we do not have these procedures. So if we could amend these processes to open up the process of appointment of judges, instead of going to Parliament and sitting before appointments committee of Parliament, this should be widened for the whole country. Let the decision be made by Ugandans, and people vote online on who is good and who is not good, and people testify. They tell the truth about you. How have you been? Are you an upright person? Have you ever been stealing things? Have you been playing around with people's women in the villages? So many things come up. So at the end of the day, decisions are made. So I think it is high time we pushed for that process. That if you are to become a judge, let you be a public figure that is respected, your integrity is tested, and therefore you qualify for that public office. As of now, I think it is affecting the way we make decisions in our judgment. And therefore, at the end of the day, we do not get what we deserve. You see, like gentlemen like the former Chief Justice, what was his name? Katurebe, in terms of personality, much as he would be with the president, but he had a very strong independent decision that the president was scared about until he had to be massaged, and at the end of the day, and if you meet him in person, he disagrees with so many things he left behind. You know, Ogola, a person like Ogola disagreed with the president all the time. I remember on appointment of the appointment, I think it was appointment of Bat Katurebe, where Ogola sent the name and the president sent back Bat's name around 4 times. That go and look for another one. They take back the same name. Go and look for another one. They take back the same name. So it was in Fort Portal where they met the president, you know. And he told the president, now for me, I'm now tired. If this cannot work, I also resign, you know. So that's how Bat became the Chief Justice. So I think we need very rigorous process. And I don't know how we convince the political leadership to have the goodwill. The goodwill is one of the biggest assets we need in some of these processes. If we do not see Uganda in the next 20 years and 30 years as a stable country, then we shall finish it off for our children. We need to sacrifice and say, let there be stability for the future of this country, so that the decisions we take today, we do not take it for our own sake. We are taking it for children and grandchildren. And we do not see this, we cannot invest in this, then they will bear the consequences. You see, if you look at Afghanistan, look at how it is. Yesterday, the women's rights were even trampled more. They made a decision that even nurses and midwives, who are the only ones allowed to go to school, yesterday they also stopped them. They even said, now you should put on, your dresses should only leave your eyes only. The rest should be totally covered. Now the women are rebelling in Afghanistan. Come to Iran, you know. So this may, as Professor said, activism should go beyond judges now. Activism should go to all right-thinking people who think that the law is the right law. You know, if you are party members of a particular party, be proactive towards things that are good for the country. Not because you are a party in government, it should not discriminate. It should be, all parties should move towards activism, that we need good governance across the board. Otherwise, the way we are moving and the way we talk about leadership, it looks like we have surrendered leadership to a particular group of people. We cannot decide, because you even hear people saying, who is the heir? The heir is normally in an aristocracy. We are in a democracy. But we are saying that the other one is going to be the next. Through what? Through election? Or through what? So
the speaker puts it graphically and
yes,
says that I believe in the Father, the Son, and the Holy Spirit.
Yes.
The Holy Trinity.
Now you can imagine.
Political Holy Trinity.
The Speaker of Parliament is saying that. That should not come from her. So we are really in a catch-22. Uganda, the country that got independence in 1962, has the greatest challenge that must be reviewed. And the whole challenge is leadership, as Putin put it.
No, even us as citizens, because we are subjects, we are not citizens.
Yes.
If we were citizens, we would stand our grounds,
yeah,
and make corrections in what is going on. But because we are largely subjects.
See, in Georgia, if you're watching Georgia right now, citizens have refused. You know, citizens said, we want to go to join European Union. The government is saying, no, we have suspended it. We are more with Russia. Now, so citizens said,
in South Korea,
yes,
last night, yesterday,
yes,
the president declared martial law.
Yes.
Parliament said,
no,
null and void.
Yes. And the president is being removed today. Is being removed today. You know? So you can see the powers of citizens. We have the powers in us, we cannot exercise them.
Because we are subjects, not citizens.
So until we define ourselves as citizens, I don't know how long it will take. So we are in a very, very serious situation. I do not know how we should reactivate Ugandans, because civic awareness is now one of the biggest diseases, because it's not there. The judiciary is supposed to do that. Awareness on human rights, what they should be doing that. Human Rights Commission should be doing that. The Electoral Commission should be doing that. All of them are not doing. We have budget problems. We have budget things. We have budget problems. So, and that is the trick they are using. Even teaching of this thing. In schools, there used to be civics. A subject called civic. Was it civics? Yeah, people used to be taught about the awareness. Who is your president? Who is the what? And you are examined, you know, about basic things about the country. But is it there now? It is not there.
It's no longer there.
So we have a long way to go. We are just marking time. I don't know. Moving without progress.
Professor, it is often said that the law is a function of politics. And in this context, there has been a lot of talk regarding the constitution of the Constitutional Review Commission by the Justice Minister, the Honorable Mao, within the broader framework of the electoral constitutional reforms and whatnot. But it's not yielding, it's not forthcoming. One of the objectives, the self-stated objectives for the Honorable Mao joining the NRM government was to actually fast track and achieve that. We are now headed towards the next electoral cycle. There is no any fruit, not even a signal to point to that. So, aren't we lost? Do we still have faith as a people that we can still correct, like you point out, legally, some of these past mistakes and then put the country back on the correct course?
Thank you even for bringing the case of the minister, Honorable Mao, in charge of, responsible for constitutional affairs, which constitution is supposed to promote good governance. The role of the constitution in good governance sometimes is overlooked, and just people concentrate on the role of the judiciary in administration of justice, forgetting the other role is as important as the other one. But he talked about patronage. So appointment of people in positions of responsibility based on patronage, not based on merit, on a technical and value capacity, is a problem in this country. I would go for scrutinizing somebody who is going to be appointed or who is in a certain position of responsibility of decision making, which can shape this country. I support the vetting, but the checklist for vetting is what I question. I would like people to know your background. What values does this person hold? Was he upright? Was he public-minded? Has he been public-minded? Has he been incorrupt? Has he or she been for social justice? What are the values that have informed the decisions and actions of this potential candidate? Not background check where the criteria is, has this person been a royalist? Has this person been without brains? Brains, I don't mean very intelligent, but somebody who, even when he knows something is wrong, he just takes the other direction because he is selfish. Has this person's background been that of courage? Courage means somebody who is informed in his or her actions by principles. Has this person been swept by the wind? You know, at times they look for somebody whose values are those of selfishness, of being swept by the wind, of not standing on his principles, and they say this is the most correct, qualified person, rather than getting somebody who is courageous and you just go for only certificate qualifications. No, they are non-certificate qualifications. Which are these values and competencies? So you were asking the question about exactly what again?
The Constitutional Review Commission, the fact that it was a self-stated objective.
Oh yes, that
by
one.
the Minister of Justice.
So the Minister of Justice himself has come out openly, publicly at seminars to complain. He's complaining that my hands are tied, my proposals have been ignored, and the other time he even made a statement justifying why he is now working inside the government. Because anybody can work with government. All of us are working with government, but not necessarily inside the government. And he said he went to promote a smooth transition. And the president was public also to say,
there's nothing like that.
There's nothing like that we discussed. And then of late he has said he made constitutional proposals which he didn't discuss with the public though, to the cabinet. But he says he has met very many stumbling blocks there. He is admitting before the public. And of late he has commented on this judicial officer, the judge of Ginger. What is her name again?
Honorable
Bukirwa. To say, this judge was making her correct things, and even if they were wrong, they can appeal, but not intervene in what she is doing. That is what he says. He says this is interference. Now, the Minister of Constitutional Affairs is supposed to be guiding us on constitutional issues, but he has now joined those in the trenches to lament. He is now lamenting. Now, which direction are we going to go? There is this lady who is normally put on Friday on NTV. What do they call that? Funny, that comic program that was started by Nandutu. Zungururu. Yeah, Zungururu. She says, you remember the lady? To go ingewa. I want to go ingewa. Now, we should be going to the Minister of Constitutional Affairs.
Yes.
He's now also lamenting.
Yes.
He's also saying, Banang, to go ingewa. The opposition is saying to go ingewa. Some members of the executive to go ingewa. The civil society to go ingewa. Now, what are we going to do? There are even people who have decided to keep quiet and say, let things move. Let me survive. They are in survival mode. They have a high sense of survival, saying if things go, whichever direction they go, let me go. But then I want to ask the political elites. We are saying there's people who understand the government processes, the judicial processes, or whatever. We need to come up and make sure that we participate in shaping the direction this nation is taking. We have a proverb in Runyankore which says that that if you literally translated, if you sit on your tongue as the head of a family and you don't tell the children and other people to clear the kraara where the cows stay, the cows will sleep in the cow dung. It will not be cleaned. Because as the head of the family, you should tell people that things must go right way. So, if the political elites who are now the heads of the family, Banyineka, have just sat on their tongue and have said, me, I don't want that thing to come from me, let it come from others. You say, but are we not walking in the political fog? And we are liable to a political accident. Let me keep quiet. So, if everybody is to go ingewa, The minister is saying to go Ingewa. At one time you find members of parliament also saying, I also don't understand. Now to go Ingewa, we should be going to parliament, but the parliamentarians are also saying to go Ingewa. I think quietly in private you may find some military officers saying also to go Ingewa. Now, have we been reduced to go Ingewa? That we cannot come together and have collective views and promote the good of this country, promote the public good, and move this country because we are at a stage of state building and nation building. We are not yet a fully functioning state. We could have temporary reprieve, we could have temporary seemingly that we are okay, but we are still not yet okay. We don't yet have a nation. We are still building a nation. Some people may think we have built a nation. No, we are not yet. That's why we see all these signs of a possible fragility of the state. And the elites are saying to go Ingewa. The minister is saying to go Ingewa. MPs to go Ingewa. We have to come up and say, okay, let's now have collective views, especially guided by public mindedness, serving the public, not merely selfish ends, private ends, public good. Government, please, when you are vetting the people to put to responsible positions, do a background check, do a vetting, but based on courage, based on principles of the public good, based on moral uprightness, based on uprightness, not based on merely royalty, merely, at times they look for people who are crafty. This person is crafty. I think when we bring this person, he can know how is better. He can know how to go about around things and confuse the opposition and confuse the judiciary and confuse religious leaders and confuse civil society. So you find the background check criteria is craftiness. People who are crafty, people who have no courage, people who cannot stand on their feet, people who are not for the public good, and then you put them in positions of responsibility. How are those going to shape the direction the country is going to, especially as a post-colonial state, who are still at the level of state building, who are still at the level of nation building. So, I want to go to your question, Mr. Moderator, about the capacity. We are lacking capacity in respect of people who are anchored in values of serving the public good. We have people in positions of responsibility who are supposed to be promoting the public good, but they are there to promote their private interests. And if the criteria for vetting, the checklist for vetting people to put in the judiciary are for those who are going to serve the private good, who have no courage. This lady has a courage. This judge from Ginger, and has made independent decisions. Instead, she has been punished for that. Come on. Where is this country going? We are removing people who have the values of uprightness and putting the people who don't have the values of uprightness and say they have capacity. Which capacity now? Let's not only look at certificate capacity, but looking at the values. And therefore, the constitutional role of the judiciary is to promote democracy, is to promote good governance, is to promote the rule of law, is to promote constitutionalism. Constitutionalism, among other things, is also to limit the powers of government. It is a known fact. It is evident truth, as the American president said. It is evident truth, and has been found out by very many commentators and researchers that power has a tendency to corrupt. All power has a tendency to corrupt. And therefore, from that basis, we need to limit all power, whether it is power of the executive, or the judiciary, or the legislature, or the church, or the traditional leaders, or the parents, or the headmasters, power has a tendency to be corrupted. And therefore, that's why human beings came up with systems to balance this power. But if we leave the judiciary subverted and denying it the capacity, space, not capacity, denying it the space to hold government officials accountable and transparent, and limiting their power in decision making, limiting their power in actions, then we shall have failed the cardinal principle of constitutionalism or the judiciary promoting good governance, human rights, constitutionalism, in addition, alongside the function of administration of justice. And when we are doing that, people think they are smart. You know, they even laugh. Oh, we are very smart. You know, we are smart. We shall just ignore those appeals from this civil society or from the media or from whichever quarter. We shall go around it. We shall even go to Parliament and offset that ruling. You know, we are smart. Excuse me. Smart in what? The smartness should be judged by our actions of state building and nation building, so that we get out of this quagmire. We were at the same level as you pointed out at independence with these Southeast Asian countries. They have gone to first world. We are here dancing around the laughing stock of the whole world because we have failed to have an orderly society. How do you have an orderly society? You must regulate it. How do you regulate it? You must have an independent judiciary. What is an independent judiciary? It's not only independent judiciary only on paper. It must be an independent judiciary in practice. How can that one happen? We must also put in order our political order. Otherwise, if the politics is not in favor of independence of the judiciary, if the judiciary is not in favor of judicial activism in favor of social justice, then we shall not build a state, a functioning state. We shall not build a nation, and we shall continue marking time as Africa has done. 6 decades later, South Korea or Singapore or whatever, they are going to the first world. They are now challenging even the West. South Korea is now the 11th, I think, richest country in the world. When in 1960-50, it was like Uganda. Because we have failed to build a state and a nation. A functioning state cannot be built on the so-called smartness. You know, this one is crafty. He knows how to twist around and confuse the population. And you find people are holding such a person in high esteem. Oh, that one, when he is talking, he will confuse Parliament. He will confuse the judiciary. He doesn't listen. He is arrogant. Do you know people are very supportive of arrogance? See, arrogance is one way of killing a state. You find somebody in a certain office exercising arrogance by not listening to the public, by not being responsive to people's concerns. And then they say, oh, that one is smart. That one is the right person to be in office. That is our man. That is our woman. Why? Because she or he knows how to cut corners, how to confuse people, how not follow the right things. Now we have reached a stage where the right people are shunned, the wrong people are praised. A country that praises and supports those people who are selfish has no future.
Thanks, Prof, for your perspective. Honorable,
Yes.
even as we conclude,
Yes.
what areas would you like to see serious reform with respect to our country's judiciary? And lastly, what message would you give to the institutional leadership of our country's judiciary?
Well, I think regardless of whether they hear or not, we shall keep repeating. One, it is important that the judiciary should be strengthened, and I believe this can only be done when there is a consciousness in reviewing all what it has done. I think we need a total review since independence on what the judiciary has delivered to this country. And then we start from there. Because if we do not do this stock taking, I think we shall be fooled for long. We need a total evaluation of the performance of the judiciary.
And the checklist should not only limit itself to administration of justice, should look at good governance, the role of judiciary in promoting good governance,
promoting democratic processes,
democratic processes, promoting
upholding
the rule of law,
you know,
and limiting the power of the executive.
Exactly. So that should be the parameter in which they should function. And then, of course, lastly, I know there's a lot of effort being put now to strengthen the capacity of the judiciary. But of course, capacity, which is one-sided, it is only the technical capacity. They are not strengthening the other side of capacity of value. Value-driven.
Courage.
Yes.
Is this person courage to make a judgment on his or her own?
Now, that is where the gap is. But all in all, we still believe if we mean well and we still can talk about it, then there's something that can still be improved. So the most important thing is for Ugandans to be very, very vigilant. We remain to speak here in this small space. Possibly, it may land into ears of some few. And that is our biggest
And we can
hope.
make a contribution.
Yes, this is our contribution.
Small as it is.
Yes. We do not believe that if you go to the bush and come back with a gun, then we can make a fundamental change. We believe by talking, by using dialogue, we can improve the growth of democracy, of judicial competency, of everything else. You never know. If East African community becomes a bigger deal, we may hide our incompetencies in that process, and possibly we shall develop better.
The one comment on East African community, by the way, we have the East African Court of Justice.
Yes.
By the way, the major function of the East African Court of Justice is not administration of justice.
No.
The East African Court of Justice is actually about the interpretation of the treaty.
Yes.
It is about promoting good governance.
Yes.
It is about promoting the rule of law.
Yes.
It is about promoting democracy within the East African region. Its mandate, core mandate, is not administration of justice. So we need that kind of judiciary.
Yes, and we need to even pray since we are now going into common currencies and all these things, can we also widen the jurisdiction of the courts so that we move beyond the Supreme Court of Uganda, so that East African Court of Justice becomes the court of last
administration
resort.
of justice.
Yes. Now, if you can do that, then you can see that so many things will change. Because to have an East African Court of Justice, influencing it may be very difficult, given the number of countries.
Can I mention something here, which is wrong there?
Yeah.
More than 12 years ago, the East African Secretariat, the Secretariat are the public servants, civil servants, came up with a draft protocol, a draft protocol on good governance, so that the whole of the East African partner states have kind of a uniform good governance structure and principles. 12 years ago, more than 12 years ago, the council and the summit have refused to table it so that it is ratified. Why? They don't want a good governance document that will hold them accountable to the citizens.
Yes.
And in that case, sometimes the hands of the East African Court of Justice are tied because they don't have an operational law operating the treaty for which to use in order to promote good democracy and rule of law in East Africa.
Yeah. So it's a long struggle. It's a lifelong struggle. So young people should join in. The young lawyers should join in. possibly the Semakades behaviors are an outcome of
The
some
unconventional
of these things.
Semakade.
Yes, because you cannot have a lawyer who is banging the table. You know, they are an outcome of a process which is stagnant. So one day we shall have revolutionary lawyers, and they will give us problems.
Yeah, but if we are not careful, we can have anarchy.
Yes.
Because such unconventional methods also needs to be given space.
Yes.
But also limited, because we can have anarchy instead of having a revolution.
Yeah.
But I think the judiciary needs to be wakened up by some extremes of the of the likes of Semakade, unconventional, although the methods are not conventional.
It's a wake-up call.
They may not look disciplined,
Yes.
but it could also be a disruption.
Yeah.
You know, at times certain things needs to be disrupted.
Yes.
And then out of that disruption,
We can move well.
society can move.
Yeah.
Yes, Honorable. Prof, what would you propose in terms of serious, solid reforms for the judiciary, and also your message to the institutional leadership of the judiciary as we conclude?
I don't think that what is necessary as a reform is a legal question, is going for the legal reforms. No. I think the problem is not the existing laws as such, or the constitutional law that we have. The present challenge of weakness in the judicial performance in promoting the rule of law, in promoting good governance, in promoting democracy, in promoting human rights, in limiting the executive, is a political question. It's a political question. I am encouraging the different actors, mostly the elites, to be citizens and not subjects, to endeavor to have the politics of constitutional review, not in legal terms, not in technical terms, but in changing the landscape, the political landscape, the value system, so that we have the right people in the right places, and then give them the autonomy that is already constitutionalized. It is not lack of the legal framework for the judiciary to exercise their performance. It is the political administrative landscape. One of them is the appointment of the Judicial Service Commission, and the appointment of the people on the bench. Because if you appoint people because of lack of their loyalty, of their courage, and you use patronage, I think my colleague here mentioned patronage. You have to remove patronage in the judiciary. As long as you have got judicial patronage and political patronage, to the extent by even the members of the judiciary, I'm told they are now corrupt. You'll find most of the new magistrates appointed in the government are relatives of the judges.
Are their children?
Are their children, are their relatives, or they are bako? I mean, that is corruption. Don't look at corruption only in getting money from people. Look at that corruption. Can we have a checklist and find out who is related to who? Can the IGG tell us, do some investigation and find out the relationship between the people who are newly appointed in the judiciary and their relation with the members of the bench? But if not the members of the bench, they sometimes exchange with the members of parliament, parliamentary commission, and the speaker, so that some of their relatives are appointed in the parliament as the other ones are appointed in the judiciary. Now, once you have that political corruption, the conflict of interest, then you cannot have a functioning judicial system and judiciary which would promote democracy, good governance, rule of law. So I don't think the judicial review is necessarily the technical question. it is the political question. So far, I think the laws we have are not so weak in promoting effective judiciary. What is weak is a political patronage and judicial patronage, which has become a culture. Which has become a culture not only in the judiciary and the politics, but in society, where patronage has become a norm. Uprightness is something that is abhorred, that is not liked. And people who are not upright in actions are the ones admired. And you find the system, the political patronage system that we are operating now rewards patronage, rewards weakness actually, rewards those people with wrong capacity in various systems, and punishes the uprightness. The case in point is Judge Bukirwa. Yeah? Judge Bukirwa, being upright, has been punished. This country, to go in war, to go in war, if somebody is upright and is punished, and those who are not upright are rewarded,
Yes.
definitely the judiciary will not perform its rightful function of promoting constitutionalism, the rule of law, good governance, and democracy in this country. I thank you.
Thank you, Prof. What can you tell the institutional leadership of the judiciary?
Which institutions are we talking about now?
The
I
Chief
mean
Justice.
the actual leadership, the Chief Justice and the Deputy.
Well, they didn't appoint themselves there. There are certain forces that appointed them there. But what I would tell them,
As a citizen.
but as a citizen, as individuals, although the whole thing is systemic, the challenge is systemic, and therefore the solution should be systemic. But even at individual level agency, I would want to tell them to have one thing, one qualification. Because definitely we all know that these are respectable people with the right knowledge, with the right judicial and legal minds. What they are lacking, I repeat, what you are lacking is the courage to make decisions that will promote justice, good governance, democracy, and the rule of law. Courage is the missing link. Courage is the missing value. Courage should be there, and through your courage, you will shape the direction of this country, and the people will live to praise you, and you will have done justice to this country. But if you don't pick up courage and you say, let me survive, if you remain in the survival mode, if you remain with that high sense of survival, definitely the institutions that are responsible for promoting this judicial review are going to remain weak. Not because the judicial officers have no legal mind. They do have no technical capacity. They do have no so professional. You know, professionalism sometimes also is taken to follow the traditional procedures. Conformity. I think we need to also have certain values and be progressive. This country needs a progressive justice system. A progressive justice system that makes decisions based on or informed by social justice, not traditional procedures, those that were handed over down to by the British. We sometimes claim that we are constrained by the Commonwealth law system. We are making a lie. First of all, I think under the Commonwealth system, you will correct me if I'm wrong, under the Commonwealth British system, the Parliament is supreme. Parliament is supreme. But under our system in Uganda, the Constitution is supreme. Isn't it? The supremacy of the Constitution. Now, the supremacy of the Constitution is not a Commonwealth thing. It is our own. So why do we stick to the commonwealth and remain conservative and remain reactionary instead of being progressive under the cover of commonwealth? No. Under the commonwealth, what is supreme in the governmental systems is parliament. What is supreme in Uganda is the constitution. Can we make our constitution supreme beyond myth? Otherwise, we say the constitution is supreme, power lies with the people. It doesn't lie with the people. We are following the rule of law when we are actually following the whims of our stomachs, rather than standing courageous and say, let's follow what is right and let's reward right and punish wrong. But we are doing it the other way around. We are rewarding wrong and punishing right. I mean, a country that punishes right and rewards wrong has no future.
Thank you, Professor, for sharing your views with us on the program. What I cannot overstate or overemphasize is the importance of courage in the administration of justice in the country. Let me appreciate Honorable Komakech for your able participation on the program as well. Our dear viewers, we thank you for keeping us company from the start up to the conclusion of this program. Many thanks to the production department for keeping us live on air. Please, our esteemed viewers, engage us on our various social media platforms. We are on X, we are on Facebook, we are on YouTube, where you can subscribe to our channel and also watch the proceedings of this show. We'll see you next time. Be blessed.